Running a restaurant means watching food and labor like a hawk. But a lot of money leaks out in places most of us never have time to review. That's where CRA's complimentary cost analysis, powered by Schooling Mitchell, comes in. Our partners at Schooling Mitchell help restaurants cut non food, non labor expenses by analyzing vendor invoices and negotiating better rates, often without changing vendors. For CRA members, this is a complimentary performance based cost analysis. No upfront cost, no risk. They only get paid if they find savings. To keep more of the money you're already earning, visit calrest.org and hit the Marketplace tab.
Hi, I'm Jessica Roots. I'm with the California Restaurant Association, and this is Ask CRA on the Confidential Bulletin. Today, I'm joined by Laura Pierson-Scheinberg and Alan Acosta from Jackson Lewis, one of our CRA Legal Center partners. Thank you both for joining us. I'll go ahead and pass it to you, Laura.
Thanks so much. My name is Laura Pierson-Scheinberg, and I'm with Jackson Lewis. I co-lead our labor relations practice as well as our retail practice, and we work with CRA partners quite a bit and know your industry. My practice is at Jackson Lewis focuses on all labor and employment, so anything that happens in the workplace, that's us. Alan?
Thank you, Laura. My name is Alan Acosta. I'm a principal in Jackson Lewis's Los Angeles office. I also practice in the Labor Relations Practice Group, and I advise employers on compliance with California workplace laws.
So today we're going to talk about Senate Bill 294, the Workplace Know Your Rights Act. And this is a new mandatory requirement for all California employers. So really briefly, I'm just going to overview what we're going to talk about. So what the bill is designated to do generally, what the bill's practical requirements are, who's covered by the bill, and how actually to comply. We'll always cover practical tips and some helpful resources. So when looking at what is the bill, right, this Workplace Know Your Rights Act, this all started off as a bill sponsored by labor unions and immigration nonprofits in California in early 2025. One bill sponsor explained that it's designated to clear up the confusion over how state and federal laws apply and intersect in the workplace when employees interact with law enforcement and immigration authorities. This became effective January 1st, so of this year, and imposes annual notice obligations. And it requires compliance as of the 1st of this month. And I know we're sitting here at the 6th, but we really want to make sure that everybody knows there is no time like the present to comply, even if you didn't do it on that date. The purchase of the statute is to really require employees to notify the employers of their rights in California, constitutional rights when interacting with law enforcement in the workplace, and other rights. Alan?
Yeah, so we're going to talk about how this law is different from the usual notice posting requirements in California. So under SB 294, there are some key distinctions. By way of background, most required workplace postings must be posted in areas frequented by employees where they can easily be read during the workday. These typically include posting them in break rooms, dining areas, and commonly accessed employee areas. SB 294's postings are different. They must be affirmatively provided as a standalone written notice to employees in the manner in which the employer usually uses to communicate employment-related information. Unlike the typical postings, SB 294 notices can be provided by personal service, in other words, handing it to the employee, email, or text messages if it can be reasonably be anticipated to be received by the employee within one business day of sending. In other words, sending it by U.S. mail is not going to suffice.
I do want to say I have gotten some questions on this, and I was like, really, do I have to print out 54 copies and pass these out? The answer is no. But however you normally communicate with your employees, they have to receive it in that way. So you can print it and pass it out. You can email it to them. You can text it to them. But the really important thing is to keep a record of that. You want to show proof that you gave it to them.
Absolutely. And so this is a different way of providing communications than what's typically been required of employers in the past. Laura, so what does the law require employers to tell employees in these circumstances under SB 294?
So the Labor Commissioner published an official model workplace know your rights notice that employers may use to comply, and it's available on the Labor Commission's website. Key informational subjects include workers' compensation rights and benefits. This includes workers' rights to disability pay and medical care for work-related injuries or illnesses, plus the contact information for the California's Division of Workers' Compensation. It also includes immigration agency inspections information and workers' protections. So if an employer receives notice of an upcoming immigration agency's inspection of an I-9 eligibility verification or other employment records, the employer must post a notice informing workers of their and their union representative, if applicable, within 72 hours of receiving that notice, kind of giving a, hey, heads up, we just got this request. The next is protection against unfair immigration-related practices, so against a person exercising protected rights. The explanation that it's illegal for employers to reiterate or threaten immigration action when employees exercise legally protected rights. So, for example, employers can't retaliate against employees by refusing to accept ID documents during the I-9 proof of ID and permissions to work, documents that appear genuine, reporting or threatening to report employees or their families to the immigration authorities, or threatening to file false reports to policy or federal agencies. So this law also requires disclosure about union and protected activities under the National Labor Relations Act, kind of what we deal with every day, Alan. Can you tell us
That's right.
about that, please?
Yeah, so these are rights related to union activity and protected concerted activities. So the notices must have explanations that California employees have the right to organize to seek better working conditions or raise work-related concerns. Explanations of prohibited conduct under the National Labor Relations Act, like discouraging union activity or retaliating against employees for union or protected activities. In addition, the notice contains language about constitutional rights that employees have in their workplace interactions with law enforcement. For example, under the Fourth Amendment, which protects employees and all persons against unreasonable searches and seizures. The notice explains that employees can refuse law enforcement and immigration agents' requests to search personal belongings or their person if they do not have a judicial warrant. It also notes that law enforcement can enter public areas without a warrant and that California employers cannot provide voluntary consent to immigration enforcement to enter non-public workplace areas. It also explains that under the Fifth Amendment, employees have a right to remain silent even if asked about immigration status and to request an attorney because anything said can be used against them in a court. Finally, the notice states that enforcement agencies, that police have rights listed above, and to update those legal developments that the Labor Commission deems material and necessary to inform employees of. Laura, the Labor Commissioner has been proactive about posting the model notices on DIR's website. How can employers access them, and what should employers do with the notices?
So, first of all, there's a language requirement. Employers must provide the notice in the language they normally use to communicate with employment-related information and that the employee understands, like their native language. So currently, templates are available in English, Spanish, Chinese, Vietnamese, Korean, Tagalog, Hindi, Punjabi, and Urdu, with additional languages expected later. Note that they are available on the website. And from a record keeping perspective, employers must keep the records of compliance for 3 years, including the dates that each notice was provided to employees. And they're supposed to be provided to new hires. So we would do the workforce as of, as soon as possible because it was supposed to be February 1 if you haven't done it already. So we provide those notices and then we keep record as I had described. And then as new hires do it, you just make it part of your new hire packet. So when we're looking at who must receive the notice and when, again, provide the notice annually to all current employees by February 1st, provide each new employee at the time of hire. So put that in that new hire packet. And then if the employee is a union member, provide it to the union or by either email or regular mail to give them a heads up. So when we're looking at who is covered, it applies to all California employers, regardless of the size. This is the same as a broad notice approach that the legislature has taken with respect to minimum wage, payday notices, industrial welfare commission wage orders, and it reflects the state's interest in especially apprising employees of their rights when interacting with law enforcement and immigration officers in light of the current events. The law itself says it is intent is to equip workers with the knowledge of their rights so that they can use it to protect themselves and their families, their neighborhoods and communities at a time of potential disruption. So coverage can be waived by a collective bargaining agreement, but at this point, given the timing, that really hasn't come up at this point. And so, I guess the next thing to look at is, what does a clear and unambiguous language entail?
Well, in this instance, we deal with this issue all the time when it comes to collective bargaining agreements. Under current labor law, what we look for is actual explicit waivers of this. It can't be language that presumes a waiver of this right. So we would recommend that employers, if they seek to get a waiver, get something that is very clear that this is something that is going to be waived moving forward with respect to the bargaining unit. As far as methods of delivery, the notices may be delivered, as I indicated earlier, via personal hand delivery, email, text, any method that is normally used to communicate employment information if receipt is reasonably anticipated to be received within 1 business day. Now, a key aspect of this is that there has to be record keeping. Employers must keep records of the distribution and dates of distribution for these notices for 3 years, including the date each written notice is sent or provided to each employee. Now, with respect to the emergency contact component, we'll talk about that. Laura?
Yeah, so the law has notice requirements beyond just providing employees with documents, too. They need to take practical steps to gather emergency contact information from their employee. Can you share a little bit about that, Alan?
Yeah, so employers must give employees the opportunity by March 30th of 2026 to provide emergency contact information and state that they want that person to be notified if the employee is arrested or detained at work or arrested or detained while performing job duties off-site, and the employer has actual knowledge of the employee's arrest or detention. For employees who are hired after March 30th of this year, this opportunity must be given at the time of hire. If an employee is arrested or detained in the conditions described in the statute, employers are required to notify the emergency contact if the employee provides one. As we'll discuss shortly, the consequences for failing to provide notice to the emergency contact are quite significant. And as you can probably guess, employers need to get ready to handle new record keeping, notice distribution, and emergency contact requirements as soon as possible. On that point of consequences, Laura, what are the risks of not complying?
So it's not nothing here. So let's talk about it. Employers will face penalties if they fail to comply with SB 294. Employees themselves can seek injunctions, punitive damages, and attorney's fees and costs to bring claims for violations. And employers can be subject up to $500 penalties for each employee they failed to comply with the statute towards. This $500 penalty may be issued for every day an employer fails to comply with emergency contact notice requirement. So, Alan, this gives this PAGA vibe. Can you talk a little bit about that? When you have these statutory penalties, it kind of always raises a potential for a claim like that.
Yeah, so just to put SB 294 in context, these are amendments to the labor code. And as a result, any violation could be used to serve as the predicate for a PAGA claim. And California, under the PAGA legislation, allows private parties to recover civil penalties for labor code violations. SB 294 does not exempt coverage of the statute from PAGA. There is the possibility that there could be a action brought to enforce violations of the labor code here, failing to provide notice or failure to notify emergency contacts, which could result in significant exposure should that type of action be filed.
So the easiest way for employers to ensure compliance with the law is to avoid reinventing the wheel and creating their own informational documents. The best practice is to provide what the labor commissioner has published on his own website. It's there for you at dir.ca.gov. As a practical measure, we recommend designing a human resources or administrative employee to keep a folder of all notices sent to employees with an accompanying spreadsheet listing the recipient's name, method of contact, notice distribution, and the date, and any employee acknowledgments. Another way to do this is if you send it via text, screenshot the text. If you send it via email, save the email either in a hard copy by printing it out or electronically on your computer that's backed up. The whole point is if you don't have proof, the burden will be on you to show that you provided it. So please try to be thoughtful about keeping this record as you do at many of your other employment records. Alan?
Yeah, similarly, with respect to the emergency contact notifications, we recommend coordinating with human resources to keep a centralized database or a list of each employee that is a database with all of the emergency contacts designated, the date that the information was provided, and the designated method of contact, whether it be email, phone, or mailing address, as well as the dates, if any, that the employers contacted them to report a detention or arrest. In addition, employers should take immediate steps to establish a way for employees to designate their emergency contact. The sooner the better, considering that the statutory deadline is coming up on March 30th. In addition, we recommend that employers review internal communication processes to ensure that notices are delivered in the same way employees communicate directly to employees over the course of prior practice. Finally, we recommend that employers train HR teams on this new obligation so that distribution and record keeping are consistent across departments and are timely delivered. Laura?
We know that our members out there are employers of all sizes. So we're talking about HR teams and these big, processes. Better done than perfect. Just deliver the stuff as you normally communicate with employees. And so if you're a mom and pop shop, again, screenshot your texts, save your emails. We're making it sound like it's quite a process, but really it is pretty basic like you do with your other documents. You just have to put it into that new hire packet or have, get those after you get the original ones distributed to your current workforce, then you're up and ready if you put that in with your new hire packet as we go forward. So we're going to monitor future updates because, as you know, this law is just rolling out as of this month to the model notice, since it will be updated annually with legal developments the labor commissioner deems necessary to inform employees of. So you would want to make sure that you're, put a note on your calendar every January 1st or 2nd after you've celebrated New Year's to go look to visit the Labor Commissioner's website and make sure that you have the most updated posters there. We're also going to be monitoring local legislative activity because cities and counties can enact local ordinances that can provide even more protections. And at Jackson Lewis, we have a blog here as well as the CRA does as well. So why don't we summarize our key takeaways here, Alan?
Yeah, absolutely. And as you mentioned earlier, if employers have not complied with the February 1 deadline, move as quickly as possible to comply. The financial penalties are not set in stone. There is some discretion there. So to the extent that you move to comply as soon as you can, that's going to lessen the likelihood that an employer would face those consequences. Again, the postings, the notices are available on DIR's website, and they are being updated periodically for additional languages to the extent those are applicable to your employees. Laura?
Yeah, so thank you so much for spending time talking to us about the Know Your Rights new law. And we appreciate hearing from all of you and look forward to talking again.